today we are in times of rapid proliferation of technologies, and so if you'll ask me what is that one area of intellectual property that needs utmost attention and that needs utmost attention to be protected, I would say no doubt it is copyright. And that is why in this era of globalization, copyright infringement has become such a sensitive issue, such a sensitive topic worldwide. Now, recently in Indian Supreme Court, there was a question that whether the offences under Section 63 of the Copyright Act is a cognizable offence or is it a non-cognizable offence. Now, last week Supreme Court held that under Section 63 of Copyright Act, the offences are cognizable offence and it is non-bailable offence. So, in today's video, we will try and understand a little bit what exactly is copyright, what is Section 63 of the Copyright Act. We'll also try and figure out what are the cognizable offences and non-cognizable offences. And as the topic of the video says, if you are downloading a video, whether you can, or if you are downloading a movie, whether you can go jail for that or not, and are you infringing some kind of copyright for that. Now, let's begin with the topic, let's begin with the video, and let's first and foremost understand what exactly is copyright. So see, copyright is a type of intellectual property wherein it protects the original work of the artist, the original work of the author, as soon as the artist fixes that work in some kind of tangible form of expression. Now, copyright is that right that automatically vests in someone, automatically vests in artist as soon as that artist creates the original work. Now, you might have this question in your mind that what is the importance of the copyright? What does it actually do? Now, copyright protects the work of the artist for any sort of unauthorized duplication. So, this is what in a very broad contours we can say is copyright. Now, before moving to the question that what is Section 63 of Copyright Act, let's quickly understand what are the differences between what exactly is cognizable offence and what is non-cognizable offence. See, if you'll pick up your CRPC and just go back of it, you will find a schedule which is first schedule, and there you can see the offences, the list of offences that are classified under cognizable and non-cognizable offence. Now, there in part 2, it is mentioned that an offence, if it is punishable with imprisonment for less than 3 years or with fine only, then in that case, those offences are non-cognizable offence. Remember, it is less than 3 years or with fine only, then in that case, it is non-cognizable offence, and also it is bailable in that case. Now, if it is punishable, if the offence is punishable with imprisonment for 3 years or upwards, but not more than 7 years, then the offence is cognizable offence and it is also non-bailable offence. Now, the court noted in this particular matter, where the question was that whether Section 63 of the Copyright Act is cognizable offence or non-cognizable offence, the court noted that the maximum punishment which it can be imposed under Section 63 would be 3 years, and therefore magistrate may sentence the accused for a period of 3 years also, and that is why it is a cognizable offence. Now, very quickly I will read what Section 63 of Copyright Act says, and it says that any person who knowingly infringes or abets the infringement of A, the copyright in a work, or B, any other right conferred by this Act, except the right conferred by Section 53A, shall be punishable with imprisonment for a term which shall not be less than 6 months, but may extend to 3 years, and with fine which shall not be less than 50,000 rupees, but which may extend to 2 lakh rupees. So here in this matter, Supreme Court has specifically said that Section 63 of Copyright Act constitutes a cognizable offence and it is a non-bailable offence. Now let's come to the topic of this video, which is very important and which we very frequently do, that whether you can go jail for downloading a movie or not. Now see, the answer of this question is twofold. It depends. If there is a content on website and it is freely licensed, meaning that you have the owner's permission to download and share the work freely, then no, in that case you're not infringing any sort of a copyright and definitely you are not going to go jail for that. But yes, if it is shown in court that you knowingly infringe or help someone infringing the copyright in the movie by downloading it, then in that case the court is going to assume that you knew of the infringement, because in most of the cases movies contains a watermark or notice which clearly says that there is copyright of that work, that indicates that this particular work is a copyrighted work. So in that case you are making an offense and you are infringing the copyright of that artist, of that creator. I will very quickly cover one more topic which we very frequently do and which is, I would say, very relevant. We have seen musics being used in YouTube. We are on this same platform, so let's discuss this one also. If you want to legally use any copyrighted music on YouTube, what will you do? What you have to do is you'll have to go out and get the approval of the original, from the original creator, in order to use that work. Now that's the second side of music licensing. Copyright laws make sure that creator gets paid for the work that they have done, and that's why YouTube music policy, that's where YouTube music policy comes into play. So this is all about the Copyright Act, what Section 63 of Copyright Act says, and if you're downloading a movie, if it is free of any copyright act, or if it is free of any copyright and watermark, go ahead, download. But if there is some sort of a copyright, be vigilant, you might make an offense which is a non-cognizable and which is a cognizable and non-bailable offense.